This is the blog that Mr. Schoenberger? I don't remember right now. Uh, this is the blog that Mark linked to, and Ed Prickett is a qualified acting licensed attorney in Texas. All right, he's gonna wait to write. I'm gonna read it. I'm gonna because I think it's insightful that even a defense attorney, well, I am also a defense attorney, but even a much more experienced defense attorney sees the trespassing issue the way I do. So there you go. I know, Mr. What the hell's his name? Mr. Freeman thinks that all the attorneys think that I'm stupid, but it looks like this guy is on my side, at least as far as some of the stuff is concerned. We have our differences. All right, he says, I was initially going to wait and write a more in-depth post on the goings-on at Leon Valley, Texas, but circumstances compel me to write now. The problem in Leon Valley is a heavy-handed police chief who views any dissent as something to be stopped without regard to the niceties of complying with state or federal law. Earlier this year, a so-called First Amendment auditor, started wandering through the Leon Valley police station, video recording what he could see. At some point, he ended up in a restricted area of the department, was confronted by the chief, Joseph P. Salvaggio, and asked to leave. Instead of leaving, the auditor, Jesus Padilla, went off on the chief and ended up being arrested. I don't see a problem with the arrest in itself, but the auditor community did. Again, he is a criminal defense. That's a state bar, Texas. I probably should have had this up, but I did look him up already, so. If you don't believe me, we're going to look it up. Greg. He has a different name, actually. Gregory Jack Greg Prickett. Primary practice area, criminal and family. He is a defense attorney. So there you go. I bet he does more family. God, family law is just so pervasive. Everybody's getting a divorce. Anyway, sorry. So the auditor community showed up to protest at City Hall, in which the police department is located, and several other issues came up. Another auditor, Jack Miller, noted that the building had signs up prohibiting both the open and concealed carry of handguns. So Miller showed up allegedly wearing a non-functional replica rubber gun openly. Instead of arresting Miller on the spot for the defense, they waited, obtained a search warrant, and sent the SWAT team to his house at midnight. This is something that appears to be completely retaliatory, but it's within the law. That was my understanding as well. This prompted more auditors to protest. Philip Turner, the plaintiff and Turner v. Driver on photography rights, showed up and was advised that the municipal judge had issued an order prohibiting photography in the court building. At that point, I became interested and filed an open records request for documents I thought would be revealing. Then the big issues arose. The protest group showed up again to register their displeasure, which included stepping on a thin blue line flag and generally being obnoxious. You guys are being seen by criminal defense attorneys as obnoxious. Tell me that my analysis is wrong. All of which is protected First Amendment rights. The police then swooped down on the protesters, arresting them for a number of charges, the most significant of which was obstructing highway or other passageway. I was not surprised when the Iranian magistrate dropped most of the charges, as the protesters did not violate the law. I am, from my understanding, not being able to shepherdize it, I am fully with him on that. unless there was something we didn't see. You see, to charge someone with obstructing, you have to have either given an order or request to disperse, or you have to actually block the entrance. Neither of those elements were present. Without that, you don't have a crime. So I don't. The big question for that on me is whether they had probable cause, and their good faith. I mean, if they show the good faith, like they made a good faith mistake, they misunderstood the law, then that'll probably cover them on it. But I don't know. Apparently a magistrate agreed that Texas Wolfman they had probable cause to arrest Texas Wolfman. So that is not looking terribly good for them lacking probable cause. Them getting a conviction is an entirely different story. So I don't think they'll get it. So the call went out for another protest on Saturday, June 23rd. While at the protest, it was announced that Chief Salvaggio was going to have a press conference, and everybody gathered around. At this point, most of those present were arrested, cuffed, and taken to the station. So you'll notice what he's not going to say here. He's not going to say that Chief Salvaggio entrapped them. The charge, obstruction or retaliation, a third-degree felony punishable by 2 to 10 years in the penitentiary. Texas law prohibits publishing the home address or phone number of a peace officer on a website, and it doesn't prohibit publishing it. It prohibits publishing it in retaliation. Oh, sorry. Yes, I went through it again. I don't think he has the correct take on it, at least not from what I see in here, but I could still be wrong. I only have one document. He has law libraries available. So, it's A1. A1. A person commits an offense if a person publicly posts on a publicly accessible website the residence, address, or telephone number of an individual the actor knows is a public servant or a member of a public servant's family or household with the intent to cause harm or threat of harm. So the state has to prove that you did it with harm or with the intent to cause harm or threat of harm to the individual or member of their family, etc. Or in retaliation. No, you have to prove it in retaliation for or on account of the service status. So, threat of harm, in retaliation, or on account of the service or status. Now, D just says that if you give them a written demand, it doesn't say you have to give them a written demand. If the actor receives a written demand and then either fails to remove it or reposts it, then that's prima facie evidence of the intent. But that's not the only way to prove it, so I don't think he's going to be right on this one. I can't find where he's right. And I Googled it too. I didn't just use the Westlaw printout, and the Googles didn't return anything. If anybody has something on this, please get it to me, because Daddy needs to know. It's a question burning in his mind, and he doesn't have access to a law library that has it. I feel bad. What happened was that a person on the chat screen for YouTube. So now here he's saying what the evidence is, and I would question if he has access to the evidence. I don't know where he's getting this statement of evidence from. So this is a question for me. What happened is that a person on the chat screen for YouTube live stream put up Salvaggio's home address. That is what this guy is alleging. That's not necessarily what's going on. It's not as if it's hard to find. It took me about 10 minutes to find it. It's determined it had a swimming pool in the backyard, and the Google blurred out the house to locate both potential family members and telephone numbers. Just because it's on the internet doesn't mean that you could then post it for purposes or with the intent to cause harm or threat of harm in other places. Because you'll notice that this doesn't say a person commits the offense if it's not posted anywhere else and the person posts it with the intent to cause harm. So yeah. It is in no way appropriate to post any of that information online ever, especially because you don't like what they've done. And this is after Salvaggio scrubbed what he could off the internet. That is probably very good advice. The problem is those arrested did not publish the address. Again, we're assuming that it's entirely this. I don't know if this is the case, but imagine, if you will, somebody posts the address of Salvaggio, and then the auditor says, "Hey, who's that? Is that Salvaggio's address? Everybody, you should call flood that or something." Or if you remember when we went over cases yesterday, God, it's all a blur right now. For 36.06, the court can infer a threat from sarcasm and other things like that. It doesn't have to be like just boom in your face, do this. So if a auditor is talking about call floods, call the chief to voice your displeasure or something along those lines. And then next thing you know, somebody puts up Salvaggio's home phone number, or somebody had, or it was up, and then the auditor says, call flood or whatever. It's just a risk. So I'm not saying that's exactly what happened. I'm not even suggesting that's maybe what happened. I'm just saying that apparently they showed probable cause. So I'm a little, I'm not saying that there's a good chance of conviction. I'm just saying that from what I'm understanding, they showed a magistrate, and a magistrate was like, "Yeah, this probably work. It's enough to get you in court." What's going to be interesting, since these are felonies, what's going to be interesting will be to see what the grand jury returns, because this will have to go to a grand jury to return an indictment, unless my understanding of Texas law is completely whacked. I believe they will need an indictment. They will not be able to proceed on a criminal complaint. So he's conjecturing here. Someone else did. Salvaggio say the individuals arrested were responsible for it. He did say that, but that starts a very slippery slope. Indeed, it does. First, the individuals arrested were not the publisher of the web page. YouTube is. I'd have to look at that a little closer, but I'm not entirely sure how that's going to apply. I know YouTube wouldn't be responsible for it. That's pretty clear. Finbar Martin is posting lots of ones where the hosts, the AOL or matchmaking.com or whatever, where they're not liable for it. So second, even if they are the publisher, he's like, well, but if they are, yeah, I think they are. I think they are the publisher. Like, I think I would be responsible for what I publish on my channel. So the sticky wicket comes in how much responsibility I have for what other people publish on my channel. They even if they are the publisher, they didn't put the address out there, and the statute provides that to show intent, the publisher would have to leave it up for over 48 hours. It does not provide that. I don't know where he's getting that from. He may be seeing a case I haven't seen, so I'm not going to say he's wrong, but I'm going to say that I haven't seen that. Again, it's if they are notified, then they leave it up for 48 hours or repost it to another website, then that is prima facie evidence of intent to harm or to threaten harm. But the state could still prove intent to harm or intent to threaten harm other ways. Here, the police acted almost immediately without giving notice to the individuals. I didn't see a notice requirement in the statute. Again, this could be something that is developed in subsequent case law, but if you remember, the elements listed did not list notice. So there were 8 elements, and giving notice or 48 hours was not among those. So in addition to the individuals arrested, a number of other people were detained in handcuffs for several hours. And as in the prior circumstances, this includes several with press credentials. That doesn't change anything. It doesn't change anything. Whose cameras, cell phones, and recording devices were seized as evidence. Yes. I am assuming that they were seized as evidence in retaliation. I don't think that they were actually looking to get evidence off them. This is a problem because those who are collecting information for dissemination to the public are protected under federal law. Yes, unless they have probable cause that there's evidence on them of the crime, and I don't know how they're going to prove that, but they may. So again, you're a statist, you're pro-police. No, I'm trying to interpret the statute, so relax. The police can subpoena the evidence. They can also subpoena the evidence, yes, but they can't seize it, at least not legally. I don't know about that. Eventually I'm going to have to get to the law library on that one. This brings up another issue, that in Texas, unlike every other state in the union and federal system, there's a statutory exclusionary rule for any evidence that has been seized by any person in violation of the law. Well, so yes, there's a couple things here. First of all, the exclusionary rule would prevent the prosecution from bringing the evidence in, but that doesn't throw some sanctions on them for having collected it. And second of all, you have to prove it was in violation of that 4,000 or 2,000 AA, 42 USC 2,000 AA. And until you prove that, or at least create a rebuttable presumption. Anyway, at the suppression hearing, you're going to move to suppress it, and the government may just say, yeah, whatever, we weren't planning on using it anyway, etc. If the cameras were seized in violation of federal law, they are inadmissible as evidence. And I don't think that they were actually looking for them to admit them in as evidence. But yes. If, as the activists are alleging, the police intentionally made bad arrests in retaliation or to curtail the activists' civil rights, then the police have committed crimes. Yes. If they've made bad arrests in retaliation, then they've committed crimes. Yes. They would need to have somebody prosecute them, and I don't know that this is going to go anywhere, but okay. That is not good for Leon Valley. I'd imagine at some point a lawyer is going to tell the mayor what this is likely going to cost the city. If the police officers are arrested, it may not cost the city anything. The police doesn't have to provide the lawyers with, or the police with lawyers. I think this guy's maybe mixing up the criminal with the civil. So, yeah, there is, like, just having lawsuits filed against the city could cost the city a lot of money in legal fees. I mean, it's not going to be a pain-free experience for the city, even if the city prevails. It's going to be expensive. So anyway, the link will be in the description. Again, you're free to agree or disagree with me. I haven't really been able to shepherdize any of this stuff to my satisfaction, so I'm swinging in a bit in the dark. But thanks for watching and have a great day.